like to welcome you to today's webcast. We're excited to provide you with information to help you manage risks that are evolving due to this current pandemic. If we took a poll, I think we would all agree COVID-19 has been extremely disruptive. Uncertainty abounds, and this uncertainty is enhancing the volatility in the insurance marketplace to new levels that we haven't seen in years. So today, our goal is to provide some clarity on 3 areas of risk management in order to help you prepare for these challenging circumstances that are here today and that are expected to be prevalent for the next 1 to 2 years. Let me introduce the friends and colleagues joining me today. On workers' compensation, we'll have David Chun and Kathleen Ross. David is an attorney with SRTK, one of the leading work comp defense firms in California. Kathleen, Vice President with us at Alliant here. She's got over 25 years experience as a work comp claims consultant. On the management liability topic, we have Travis Barnett, also Vice President with our Professional Solutions Group out of Utah. They're 100% focused on management liability. And our very own Roberto Rivera, he is an attorney by trade, a Vice President in our Salinas office, and our foremost expert on contractual risk transfer. Let me turn it over now to David and Kathleen.
Okay, good morning, everyone. Just a little bit more about me. I'm based in Fresno. A good part of my practice is devoted to agricultural and construction clients. I know a lot about what many of you do. And these days, I'm spending pretty much every day talking to clients about COVID and how it is impacting their workers' compensation as well as their business in general. So let's get started. I want to give you sort of a preview that the presentation, this part of it started with when the executive order was in effect. And towards the end, as we were finalizing this, SB 1159 passed into law. So we added some slides towards the end of this segment to make it current and relevant. The base of it, the foundation, all came up with the executive order. So I think it's important that we start with that. It's a rebuttable presumption that we're talking about for the executive order as well as the SB 1159 statutes. What that means is that if certain factors are met, then an employee contracting COVID allegedly industrially can be presumed compensable, and it can be rebuttable by evidence that is found outside of that presumption period. Under the executive order, there must be either a positive test or a diagnosis plus test, and the diagnosis must be done by a physician or surgeon. They're the same as far as licensing goes in California, not a chiropractor, nurse practitioner, or physician's assistant as far as the executive order goes. Okay. That changed with SB 1159, but if you have a case that was under the executive order, that was the rule. The positive test or diagnosis must have occurred within 14 days of labor or services. Labor or services performed at the direction of the employer and outside of the employee's residence, with one exception, if the residence is considered the workplace. And the last day worked must be on or after March 19, 2020. If it's a diagnosis only, that diagnosis must have been done by a physician provided by the employer, pre-designated by the employee, or a group health provider. And then that diagnosis must have been confirmed by a positive test within 30 days of the diagnosis.
To supplement what Dave's mentioning about the test, I want to bring a perspective from claims handling. What we're finding on the front lines is that the majority of claims submitted are denied for lack of a qualifying test. So this component of the test is really key, and the specifications that were mentioned are very important. So I just wanted to add that to Dave's comments.
Yeah, thanks, Kathleen. And just anecdotally, in my practice, I'm getting a lot of blind applications, meaning they don't have evidence, not even a positive test, as Kathleen mentioned, Or on a case recently, I received evidence of a positive test, but I don't know where it came from. It was a one-page printout by an unnamed RN. Didn't tell me where the test was done. It did say COVID positive, but it had nothing else. So I demanded more information. So there are no real list of specifics that the tests have to provide as far as information goes, but at the very least, it has to be authenticated by where it was done. It doesn't, the statute, the executive order or the statutes under SB 1159, they don't say this specifically, but I would say I would require that someone sign off on it. You know, who conducted it, who read it, and what facility. As I mentioned earlier, the presumption is rebuttable. You can rebut that presumption with evidence that is found. If you're within the time period of 30 days or 45 days, then you want to use that right away and have it as the basis of a potential denial. If you find it after the presumption deadline, after the 30 or 45 days, you can only use it successfully if you could not have found it within the time period, the 30 or 45 days, with reasonable due diligence. So if someone was hiding the ball, if the applicant was hiding the ball, and you couldn't find that evidence until after the 30 or 45 days, you can still use that information to eventually deny the claim. And under the executive order, the employer or carrier TPA has 30 days to deny from when the claim form was filed. Again, it's not timely denied. It is presumed compensable, and you can only rebut that with evidence that was found after the 30 days that could not have been found within the 30 days with due diligence. And the executive order applied up through 60 days after the May 6, 2020 executive order, so up through July 5th, 2020. For temporary disability, an employee does not get that until he or she exhausts all COVID-specific benefits for sick leave. That includes 4850, which is salary continuation. And TTD must be recertified every 15 days thereafter for the first 45 days following the diagnosis. If the diagnosis or test was prior to the executive order, the employee must obtain certification within 15 days of the order, documenting the period for which the employee is claiming TTD status. Then the employee must recertify for TTD every 15 days for the first 45 days.
And if I can add again, offering insight from actual claims handling administration, what we're seeing is thankfully the majority of claims submitted are, with the exception of a couple serious cases, there is zero to minimal temporary disability paid and the claim is being closed. So I would say it's going better than I think a lot of us expected, at least at this point. So temporary disability seems to be where the benefits are being limited.
Thank you, Kathleen. So many of you, if not all of you, probably been involved deep into the discovery process of when an employee tests positive and or if they are claiming that the positive COVID result is industrial. Okay, everyone has heard the term contact tracing. With the limited time of investigating positive COVID tests as to whether or not they are industrial or claimed to be industrial, discovery is very important. And, think of it as your regular high-profile claim that you typically had 90 days to do, but now you got to do it within 30 or 45 days, depending on which statute applies, the executive order or one of the three statutes under SB 1159 that we're going to talk about in a few slides here. So just like if you don't deny a claim within 90 days for regular workers' comp claims, if you don't deny one within 30 days, then that's it, unless you can find evidence to rebut that presumption after the 30 days. And the investigation period or the clock starts ticking after a claim form has been filed. Okay, so time is of the essence. You got to ask why. The questions that you all probably have a list on. A lot of my clients have a good investigation company on hand who handles a lot of their claims. And so that investigation company has an outline of questions that they've worked out with the employer to ask all of these contact tracing and causation questions. So even if the presumption applies, you still have to ask why. Why, where, who have you seen? Have you been exposed? as well as your own internal investigation at the workplace as to whether or not others have been diagnosed with COVID and where they are in vicinity to the employee that you are focusing on.
Yeah, I agree with you, Dave, on that. We are finding that the carriers, when they do receive a claim, they really are considering all the information. They're not just automatically accepting these claims or relying on the test. So it's really important to have that baseline initial employer investigation, and as David said, ask these questions because it is making a difference and can impact the compensability of the claim. So don't skip this process because you don't think it'll make a difference. It does matter.
Thanks, Kathleen. And these are some additional questions along with others that you may already be asking in your situations. I'm not an OSHA expert. I know a little bit to be dangerous, but we do have OSHA experts within my firm who handles OSHA matters as well as Department of Labor matters. But there are some overlapping issues between OSHA, the Department of Labor, as we'll talk a little bit more about later, as well as the Department of Workers' Comp on these work-related COVID situations. I'm just going to let you read that real quickly, and it's in the slide, so there's not a whole lot more to talk about. So now we come to SB 1159, which was passed by the legislature on August 31 and signed by Governor Newsom into law on September 17. That created 3 statutes. They all start with 3212, and there are 86, 87, and 88. 86 basically is the executive order codified. They turned that into a statute so that it goes on beyond July 5. So that applies from July 6 through 1/1/2023. 0.87, which you may not really, it might not be as applicable to you, applies to frontline employees like police officers, firefighters, and healthcare workers. 0.88 is probably the one that most of you are focused on and maybe losing sleep about the most. That applies to the outbreak situation. So if you have a date of injury on or after July 6, 2020, and if there is no outbreak and 0.87 doesn't apply to you, then there is no presumption applicable, so you treat it like a regular 90-day timeline type of claim. So it's really important that you determine whether or not your company and an employee who is claiming an injury falls within one of these 3 statutes. The reporting requirements for employers really is focused in on the 0.88 statute about the outbreak. So on or after September 17, 2020, which is when it was signed into law by Newsom, employers must report all positive COVID-19 cases to their carrier or TPA within 3 business days of notice. And it applies retroactively to July 6. So you'll see in the slide that positive cases from July 6 to September 16, you have 30 business days or by October 29, which is coming up in 13 days, to report. The statute doesn't talk about filing a claim form. This is just for positive tests, okay? That needs to be reported. And unless a claim form is actually filed, the employee's identifying information is not to be provided. And it's bad if you intentionally submit false or you fail to report. You get civil penalties up to $10,000, and that could be administered by the Department of Labor, the Labor Commissioner. 0.86, as I mentioned earlier, is basically the executive order codified. This one added that in addition to a medical doctor or doctor of osteopath, a California licensed physician's assistant PA or nurse practitioner acting under the review and supervision of a California licensed MD or DO can be the one to diagnose. And the same requirement of within 14 days of the last day performed, work performed is still there. So they added the PA-NP provision. You still have to exhaust COVID-specific benefits. The TD requirements are still the same, and it's a 30-day presumption, just like the executive order. And importantly, for all 3 statutes, no liability to the death without dependents unit. So if your employee catches COVID, it's industrial, they die without any dependents, then the state doesn't get that. And here is the outbreak slide, 0.88. Okay. It applies to employers with 5 or more employees. That probably applies to most, if not all of you in the audience. If you have 100 employees or less, the test of whether it's an outbreak is whether 4 or more employees test positive in a 14-day period. If it's over 100 employees, 4% or more test positive within the same period. And importantly, in addition to that definition at the top of the slide, local, state, OSHA, or superintendent agencies can order a specific place of employment to be closed, thereby meeting the definition of outbreak. And if an employee tests positive during an outbreak, that is when the presumption applies. And this one, differently than the 30-day presumption, is a 45-day presumption. And again, there is no DWD, death without dependents unit liability.
Right. And if, this section here, I know has a lot of employers really concerned and confused with, the outbreak math that's going on. And the reporting requirements, Dave, as Dave explained, they're really like nothing we've ever seen being put on employers. Your claims administrator, carrier, or TPA is going to be responsible for doing this outbreak math, if you will. Just remember that to be compliant, you need to do the reporting. What we've seen, and hopefully you've experienced this, is that you've gotten some very clear guidance and reporting protocols from your claims administrator. A lot of them, have done a great job. If you have not, I really encourage you to reach out to your broker or to, your carrier account executive, because they have very straightforward and hopefully user-friendly guides for you to use in reporting, because, as Dave mentioned, the penalties for not doing so are significant. So I just wanted to really emphasize the importance of that, working with your carrier.
Thank you, Kathleen. 0.87 is the statute that talks about the frontliners. A lot of the same requirements: positive test within 14 days of the last day worked. This is a 30-day presumption. And there are some requirements about not all healthcare workers get this presumption. There are some exceptions depending on if it is in acute care, like a hospital or urgent care, versus an ambulatory physical therapy facility type of location. And there's some issues with that, but I'm not going to get into that because it probably does not apply to most of you. If you do have a situation like this and you want to talk about it some more, feel free to contact me offline. And again, for this one, there is no death without dependents liability. And that's it for our segment.
Thank you, David. Thank you, Kathleen. Right now, we're going to turn it over to our expert on management liability, and that's Mr. Travis Barnett.
Thanks, Mark, and thank everybody for getting onto this webcast with us. As Mark stated, my name's Travis Barnett. I am Alliance Management Professional Solutions Group leader out in the Western region, and so I head efforts out here in the western half of the United States. And so at this point, COVID has caused several dynamic challenges in these lines of insurance, and it continues to evolve at a fast pace. And there is still some uncertainty that we have been experiencing on these lines, not only from a claims perspective, but from just a marketplace dynamic perspective in general. So walking through, I want to quickly go through some claim scenarios that we've seen and anticipate seeing as the pandemic continues. Something I do want to iterate at this point is keep in mind that one of the key things about claims, I hear this regularly from clients. I hear regularly that, everything is buttoned up, we're good to go, and then a claim comes in and they say, these allegations are meritless, they don't have any stance, we don't believe in this. The one thing that I always tell my clients in this scenario is I help them take a step back and realize that allegations brought against individuals and companies still usually require being defended. And that's where the insurance and these things come in, whether or not they are meritless or not. So jumping straight into this, we're going to go into the directors and officers liability and a couple scenarios that we have started seeing. The first is actually related to regulatory actions. The DOJ and other government enforcement bodies have committed to aggressively pursuing and investigating companies and the directors and officers for for improper conduct related to business actions during this time. And it's one of those things, going back to what I just stated, that even meritless allegations that can happen that can trigger these things. Examples of this that we can provide would be like price gouging practices or anything else that they can say that consumers or others are being taken advantage of, amongst other things, whether it's antitrust or whatever. The next scenario, which I honestly think is making insurers even more nervous than the regulatory actions, is the potential for an increase in insolvencies and bankruptcies from companies. And now, well, this may not be something that is actually, something that your company needs to be concerned about or not. It is something that is going to reverberate through the D&O marketplace and does cause for concern for every single one of the insurers that writes directors and officers liability insurance. And the reason for this is if your D&O policy is structured properly, it can become a target to the creditors in a bankruptcy scenario. And the claims will likely arise against the company and the directors and officers because the creditors will want to recoup as much money as possible in these scenarios, and they will come after every deep pocket and every asset that they can. And so these are some of the things that insurers are worried about that we have started seeing. We've started seeing insurers even putting on specific exclusions for creditors and bankruptcies, and it is something to keep your eyes out for, and it is something that will continue to gain steam likely as this pandemic continues to progress and if companies are not able to navigate through these waters. Moving forward, employment practices liability. Now, this is an interesting one because whenever you're dealing with people, it causes, you can get some pretty crazy things that come out. Employment practices claims are known to be higher frequency and usually lower severity when compared to directors and officers liability claims and others. We are seeing EPL claims on the rise. And here are some trends that we're seeing. And another just brief snippet for you. Employers' relations with their employees and customers are extremely important right now as companies continue to do business in this pandemic and in these unique times. We find that people are heightened in their viewpoints of how certain things are going along, whether it be masks or even coming into work, or just every scenario is different. So we do encourage everybody to be very cautious in these times. So some examples of things that we're seeing related to COVID-19 that were coming out, I have listed here on the slide. Workplace retaliation, and you can spin these in several different ways. But we are seeing claims on these where people have opted not to come into work and have felt that they have been retaliated against when they do decide to come back to work after the pandemic crisis has settled down just a little bit more. Those who chose not to work early on the pandemic. Hostile work environment, I don't necessarily need to go too much into this. If they feel like there's a hostile work environment, we are seeing claims there as well. Now, wrongful termination is an interesting one, and this one relates that we're seeing actually more and more, especially as the year continues on, especially for companies who have had furloughs that have lasted through much of the pandemic time. And during this time, we have seen that some companies have actually done an internal look and have decided to do some restructuring when it comes to their workforce. And in these scenarios where they have had reductions in forces, we have seen some claims start coming in related to these with wrongful termination and why these employees were potentially let go. Discrimination matters are also something that can be related to not only the current pandemic that's going on, but also some of the other relations and interpersonal relations that we have in this current time period where there is quite polarizing things going on. It's very interesting to say that with the current environment that things have been exacerbated by everything that's been going on, and we are seeing that insurers, especially in the EPL space, starting to pull back quite a bit because of this. And so discrimination as far as COVID-19 is concerned, even those employees, an example of this would be essential businesses where people are having to work that exhibit symptoms that may not even be COVID-19, but still are feeling discriminated against during those times. So those are some things that we are seeing and actively, and quite honestly, the one that we've actually been seeing a bit of more activity on is also the wage and hour front. And now this is typically a hot topic discussion during normal times, especially in jurisdictions like California. But sadly, the pandemic does not appear to have provided any relief whatsoever in this. And in fact, we've actually seen an increase of these here recently. And we have seen, product claims come in from California quite regularly through the pandemic. And so some of the issues here that are arising from this is just the evolving practices to maintain that safe place for people to work, and so they feel safe, and how that's applied with the current wage and hour laws, with donning and doffing and everything else, and making sure that everything is buttoned up. It does add some increased areas to watch. As far as the added scrutiny on the breaks periods and overtimes for people who are worked as government deemed and essential businesses, especially where you have, tying back to the employment practices scenario with the workplace retaliation, where you have people who voluntarily say that I don't feel comfortable coming into work, and others are having to pick up the slack for those individuals. Moving on past that, ultimately I can list off things all day long about the issues and claim scenarios that we're anticipating, that we're seeing. But the bigger thing is what is the impact on this marketplace? What is happening? Well, I can tell you that the insurers in these management liability lines are being hit quite hard during this time, and we are seeing them take action on an active basis. So some of the things that we're seeing is increased underwriting scrutiny, where insurers are not just kicking the tires on submissions, but they're actually digging deep into these submissions. They're requiring additional COVID-related questions for the business. They're asking additional questions about furloughs. They're asking questions even about your cybersecurity protocols. One of the things we are seeing in conjunction with this is that they're being very careful with how they're committing their capital to risks. And we're also seeing that non-incumbent insurers are being very cautious about the new business that they are putting on their books. And we are actually hearing and seeing, as we get further into the fourth quarter of 2020, that insurers are actually being even more cautious about writing new business. And sometimes they're waiting for senior leadership to allow them to do so. And also something else is that I know there's some people who say, well, why don't we just currently extend our current policy for a while to get us out of this? Well, I can tell you that many of the insurers are actually not agreeing to extending their policies due to the pandemic and the issues that they're seeing from a claim scenario. And the one key thing I'd like to say about the claims is it's not necessarily that they've been hit yet, but it's the known but not it's the known claims but not reported, and those issues that they're seeing happening that's causing the concern. Now, the further restrictions on things as far as classes of business, lines of coverage, and even jurisdictions are something that we're keeping a close eye on. And I don't mean to poke too much at California, but I can tell you that wage and hour and EPL are things that are on people's mind in California, and insurers are watching it and being even more cautious than they were previously, where they have already been extremely conservative. We are starting to see insurers contract their limits and watch for aggregation issues, and we're seeing them reducing their limits in many instances. Limitations and flexibility on coverage is one that I actually do not care for too much, and I mentioned a little bit during the D&O section about this. We are seeing people removing things such as wage and hour defense costs coverage. We are seeing people limit regulatory coverage on the D&O. We are seeing people starting to, even limit things on EPL with certain exclusions just to buffer themselves from things like reductions in forces and furloughs with specific exclusions. And that ties directly into even increasing retentions on many things, whether it's specific retentions for certain risks as relates to the pandemic and other things related to the business, or even reductions in forces. California EPL, we are seeing these things increase. So with the impact on the marketplace, I do not want to let you all and leave you all without any thoughts from me, from what I'm seeing and having successes with in comparison to what insurers are seeking. The biggest key I have here, and I highly encourage each of you to do, is approach the insurance marketplace early and discuss renewal strategies with your insurance broker as early as possible to align your goals and expectations. A very strong renewal strategy is key when it comes to having a positive renewal. And a big part of this is differentiating yourself from those who are out there, because in some regards, unless you have a conversation with them, they're going to rely on what they can find online through their searches, through the submission, and there can be some errors in the way that they're viewing things. And so being active and making sure that your broker and that the insurers are understanding what your differentiating keys are from others that are in your industry class or even in your area are big keys. One thing that we are encouraging all of our clients that we're going to do is broadly market the programs to non-incumbent insurers, just to validate those insured renewal options, to make sure that they are the right relationship, and that even if there are hard times, that they're willing to step up and do what's fair for both the client and for themselves, and to prove that they're willing to stay on the risk. And at times we do see that change is merited, and that those hard conversations at times, especially for long relationships, that you do have to make those decisions to do what's best for the business. And overall, we do encourage you all to do a 360 review of your insurance programs and consider, solutions that you haven't necessarily looked at in the past. And I'll kick it off with wage and hour group policies. Trying to find coupling together, finding a way to get full wage and hour coverage is something that we target and have seen that can be done. And pulling that across several companies is something as far as innovative ideas, unique ideas. Explore different insurance structures. This could include anything from increased retention deductibles, co-insurance, shared separate limits, reducing your limits on your primary layer, and then seeking excess layers on top of that. Things like that, as well as something that does come out occasionally. There's even looking for defense-only type coverage. And so these are some of the innovative things that we encourage you to look at to try and narrow down your risk transfer as you go through these times, and as some companies are struggling. Some other things to keep in mind are account receivable trade credit insurance, commercial crime, and the last thing before I turn the time over to Mark and to Roberto is we are seeing a very high volume of ransomware cases against companies. And it's not a specific type of company, or specific industry, or even area. We are seeing ransomware attacks, shutting down systems, computers, whatever, and holding people hostage on a daily basis. And this is something that's continuing to increase, and we're actually encouraging our clients who currently do not purchase cyber insurance to really take a deeper dive and look at purchasing cyber insurance at this time, because we are seeing that since there's been a large number of the workforce that started working from home, that there has been a major uptick in ransomware attacks. And we do recommend this to every single one of our clients, no matter what the industry. And Mark, at this point, turn it back over to you.
Thank you, Travis. Our cleanup hitter today, again, Roberto Rivera, wants to give you some tips, what you can do with your risk management program to deal with this current pandemic. Roberto.
So good morning, everybody. My name is Roberto Rivera, and I am an account executive for Alliant Insurance Services in Salinas. I've been in the insurance and risk management industries for the last 20 years. I am an attorney by education and specialize in high-risk industries, specifically in agriculture and construction. For the past 7 months, all of us have been dealing with the pandemic and its effects on our operations. We have learned how to cope as best as possible and continue to deal with this dynamic environment. There are a couple of things we have learned that we'd like to share from a risk management perspective, specifically 3 key areas. First, we'll talk about what you can do today to manage your risk. This is based on the principle that you can only properly prepare for the things you understand and make the best decisions that you can for those you don't. Second, housekeeping items. These are the basic things that you should be doing to understand your program and what you should be looking at in your insurance policies. And third, preparing for the future. Large clients, we learn a lot from them. They have a number of resources that are focused on a company's operations and how the pandemic has affected them. So with this in mind, we'll share a couple of the items that we learned to look at periodically to help us through this. So what can you do today? We've been working on this presentation since we realized the pandemic would be with us for a while. We've learned in that time 3 key areas that need some thought. We all either have actively or passively already done this. At this point, we've been dealing with this for a while. But it is important to develop a known protocol of business practice around this specific risk. You can expect, as part of the business underwriting process, that your insurers will want to know how your companies have dealt with the pandemic in your operations. It'll be a key element of underwriting. What you have learned and what you have done differently. For the next year, as Travis mentioned earlier, you can expect your insurers to push on some insurance rate and premium growth because they're also suffering the effects of the pandemic. They've seen some increased claim payments as well as a slowdown in the general economy, so their premiums are down. So they're under stress as well. So we have been working with clients to do 3 things. First, analyze the impact of the pandemic and critical issues. Supply shortages, right? The folks that supply your companies in both materials and people, and the continuous dealing with constant change in the business scenarios as this extends. What do you need to do to maintain efficient operations? As efficiency drops, your processes suffer and therefore higher claims. Second, identify worst-case disruption scenarios. For example, we're coming to the end of the growing season in one of our clients' big industries where there traditionally has been an uptick in E. coli claims during this period. So how is COVID going to impact foreseeable losses? Is there a compounding effect of COVID in the company's worst-case scenario? That's kind of what we work with our clients through. How are we going to deal with these known losses? And then third, communicate. Just like what we're doing today, you share our lessons learned. We can also share that the companies that are best at articulating their experience will heat off the worst of the rate and premium increases. Let our employees know what you are doing and how you're doing it. Remember, you have a duty to maintain a safe workplace, and doing this will be key. This next slide gives you a specific group of exclusions you can ask your broker to review and provide advice on how to deal with. This will help you today to get an understanding of where your insurance programs is. All your insurance policies contain a series of exclusions and modifications, as we all know, that will affect the availability of insurance. And with a tightening market, you can expect insurers to take a broad reading of each. Our recommendation is to have a conversation with your insurance broker and ask for a review of your policies in light of the pandemic in order to try to figure out what pitfalls your program might suffer. Some of the most common areas that we discuss are, 1, pollution exclusion, as noted there. They are common in all general liability policies, and some policies define viruses as pollutants, so that would be excluded already. It is preferable to have your policy silent on that issue, but if you do have an exclusion, it is worth a conversation with your advisor of what can you do for it. Second, fungi and bacteria exclusions, which are similar to pollution exclusions. Bacteria and fungi exclusions should be understood in the context of your company, but note that while COVID is not a bacteria, it can bring around illness and secondary infections. So it can come into play into this issue. Third, intentional acts, and Travis kind of mentioned that earlier. This would be a carrier's defense to any claims you might want to consider around any large gatherings and those that don't adhere to recommended guidelines, county, state, federal, even as those may change throughout time. And then fourth, probably the most important for what we've seen develop in the last 7 months, communicable disease exclusions. This last exclusion is the most important and worrisome as it is the broadest. We have seen an uptick by most insurance carriers to include these types of exclusions on their policies. They're designed to cut coverage on any communicable disease, something that is overly broad and creates a large hole in anybody's program. Now, there's things you can do around that. So we have spoken over the top 2 topics thus far. First, review your exposures by analyzing the impacts of the pandemic and critical issues around your operations. Identify worst-case scenarios and recommend the need for clear and frequent communication and documentation of this. This is key for your underwriting process and controlling your costs in the future. Second, do a little housekeeping. Have a conversation with your insurance broker or advisor about any possible gaps in coverage and how will you prepare for renewal in light of those. That should be happening right now. And third, this is the final slide, which is basically a reminder to put your company in perspective and consider what would happen if there's a continued disruption in the marketplace in 6 months or a year. I think that having that plan will be key, and communicating that with your insurers will help them alleviate some of the concerns they might have. We're all in the same position, and what we can do is learn the tools to help us identify and resolve these types of issues, most of which we haven't dealt with in the past. In our experience in this COVID environment, the companies that follow the above recommendations will be in a stronger and more secure position when it comes to claims and insurance at renewal time. So I hope the slides above provide some help. With that, it was short and sweet. I hand it off to Mark for any questions and closing remarks. Mark, over to you.
All right. Thank you, Roberto. Thank you, everyone else as well. Yes, we do have a few questions. Question for you, Roberto. You talked about communicable disease exclusions. How successful have you been in the marketplace dealing with those? Any recommendations for the food industry and workarounds?
It's a tough proposition, but we have been successful in limiting the communicable disease exclusions, which basically would be for every communicable disease, limiting those to just COVID. So a COVID exclusion, we especially in the food industry, you are selling a food product that people are going to be eating theoretically, and therefore they're going to be subject to a lot of communicable diseases. So trying to limit that coverage to just COVID would be one of the workarounds, and there is success with that approach. It will definitely depend on the company and who your insurer is.
Back on the work comp, a topic for Kathleen and David. Does the July 6, 20 date apply to the date of positive results or the date tested?
Neither. The date of injury as to which statute applies is the alleged date of injury. So when the employee thinks that they caught it. And in my cases, I've seen most of them being alleged as cumulative trauma. So depending on that alleged date of injury, then you can look at which statute would apply.
Another question here about SB 1159. When reporting non-industrial COVID claims, do we need to request a copy of the actual test from the employee?
Kathleen, you want to take that from a claims perspective, what you've been hearing?
Well, yeah, it's a good question, and one that I know employers are concerned about because they don't want to infringe on employees' personal medical information if they're not filing a claim. And Dave, correct me if I'm wrong, but I believe the language in SB 1159 just says that they need the date of the test and that the employer needs to have reasonable knowledge of a positive test. So if I read that, I'm thinking the employer does not need to request the actual test. Would you agree?
I agree with that. The specific language says knows or reasonably should know an employee tested positive. However, if you have any other rules or laws that you are thinking about, or requirements about off-duty status and whether they get benefits and those types of things, it may be pertinent to have that positive test for those purposes. But for 1159 reporting purposes, there is no language requiring that you have the actual test.
We have another question here. Where do I file the SB 1159? How do you file where do you file the claims?
The reporting to your TPA or carrier, is that what the question was about? If that's the case, if that's the question, that would be specific to your TPA's requirement. They usually have a portal, some sort of portal, at least the TPA clients that I'm dealing with. As far as claims from an employee, you deal with them just like any other claim, meaning that if you actually get a DWC-1 claim form signed and completed by an employee and they're alleging that they contracted COVID at work, then you would handle that like any other workers' comp claim, whatever your protocol is, which is to provide it to your TPA and have them take it from there.
Yeah.
Hopefully that answers both scenarios.
Yeah, and just to clarify for the audience, TPA is third-party administrator. It's basically just a fancy word for the people who handle the claims. It might be your insurance provider. So if you're with, say, State Fund or Zurich or Hartford, that would be your TPA. Travis, you mentioned approaching early the marketplace. What do you mean by approaching early? What's the time frame?
Typically, if you approach the marketplace, I would start having conversations with your broker between 160 and 120 days before your renewal. And as soon as you have the submission information available, I would absolutely ask them to start looking at your risk. As soon as they have the information, the earlier the better. They should have a good idea, especially if you're a private company, to be able to handle those items right away and give you a sense of where they're going to be.
We know California is a tough marketplace. What do you see characteristics-wise in California right now? And is wage and hour coverage available in California?
So as far as California is concerned, I mentioned it during my portion of the presentation. It is continuing to be extremely tough. We are seeing insurers still providing terms, but they are doing it on terms that they want. We are seeing that those who have provided like lower retentions, deductibles on employment practice liability, seeking substantially higher as well as increase, especially if you have any history of any claims activity. As far as wage and hour is concerned, we are seeing insurers substantially pull back on the wage and hour defense costs. And in fact, we have seen some insurers even pulling back, saying they're no longer providing the full wage and hour policies just due to their loss ratios, period.
David, can you clarify the formal definition for codified?
Sure. The executive order was an emergency order issued by the governor. So basically, codified just means that SB 1159 turned that executive order into a statute that goes into the books as new law. So if you look at the labor code, where most of the workers' comp laws are contained, those are all statutes. And so the executive order got codified, meaning it got turned into a statute now, based on SB 1159.
Another one here for Travis. What claim trends are you seeing in the cyber privacy liability area? I know that cybercrime has kind of trended up. If you have maybe a claim or two example to share.
Yeah, absolutely. So, one example I have seen is from a client of mine earlier this year was they were watching the account receivables, account payable department, a hacker was, and watching how those flows were going back and forth. And there was an invoice that was sent to the accounts payable department, and somehow the hackers were able to grab this invoice midstream and doctor it, use the same email address of the actual person who was sending it, send it on, and next thing we knew, there was over $3 million of the client's funds that were sent fraudulently. Fortunately, they were able to use some close ties to the FBI and some other things to recoup the majority of it. But it is something we're seeing. As far as other things we're seeing, the ransomware attacks, as I mentioned earlier, is probably the biggest thing that's driving the cyber insurance marketplace right now. In fact, we're hearing that, anything from Clark County in Nevada, who has had a substantial issue here in recently, where they chose not to pay the ransom and then had some records of people essentially out on the web afterwards. We've also heard, I've had other clients, one actually out here out west, that the day before their renewal, they received a ransom attack and were locked up for $1.4 million. And sometimes it's just locking you out of your systems depending on what you do, or it could be also taking important information and threatening to disseminate it out to the public that you do not want out there. So those are some of the things that we're seeing right now, and insurers are seeing it quite heavily at this point.
30 seconds, David, Kathleen. If there's a successful vaccine and this pandemic is resolved before 1/1/2023, any chance that SB 1159 gets changed?
My guess would be no.
I agree with you.
Yeah, even if the vaccine comes in the next 6 months to a year or whatever, and all of that, the workers' comp system is such that once a claim is made, whether they get that vaccine and are all better, that is a separate issue than them pursuing a claim. So I don't think so.
Roberto, 30 seconds. What information would I discover from a review of my insurance policies, and when is the best time to conduct this kind of assessment?
I can pinch hit for him here, Mark. This is Travis. I would say making sure after the renewal to make sure that you have what you anticipate that you were supposed to have compared to your binders in the previous year policy. But then right before your renewal, as soon as you start talking to your broker, I would kick the tires on those policies and re-review them so that you can get your requests, if any, to the insurers early in the process to start negotiations. So it's included in the negotiations.
All right. Thank you, sir. Again, thanking everyone for attending today. We hope that we were able to give you at least one or two good nuggets to take back with you and help you improve your risk management programs. We've got the contact information here on this slide for everyone, cell phones, emails. If we can be of further assistance, please do not hesitate to contact us. Have a pleasant weekend.